So, can we fix this thing later on, or
Yeah, when's your next meeting?
1:30, I think?
Okay, I'll be gone by then. Yeah, I just,
Well,
We are approaching the 10 o'clock hour. I'll check in with Lindsay. How are we doing on quorum?
I'm counting up now. We're about halfway there.
Okay.
Just waiting on one more. Okay, we are at quorum.
Great. Thank you, Lindsay. Now that we've attained quorum, I'd like to call the December 3rd meeting of the Vermont Criminal Justice Council to order. And our first order of business, it's a rather long agenda with some interesting items there, would be a motion to accept the agenda as written, or if there are any other additions or deletions that need to be considered at this point. Otherwise, we can move, I'll entertain a motion to accept.
Mr. Chair, I make a motion to accept. Anderson.
Okay, Sheriff Anderson, a second.
Peterson seconds.
Okay, we have a second. All of those in favor? I'm probably ahead of Lindsay, but we'll raise our hand. There we go. We got the poll up. I got to remember to slow it down. Give us a second anyway. Okay, we will proceed with the agenda as previously distributed. From the chair's seat, I don't have any lengthy updates other than a reminder that we have a hearing scheduled for the 16th, which would be our regular hearing date for December, and that we should plan on a full day for that. So I will be at the academy. May be useful for those that are able to attend in person to do so. But just a reminder that 16th, as things look right now, will be a full day hearing. Moving on to the next agenda item, we have two sets of minutes. The November 5th regular meeting of the council and the November 18th hearing that was held. I will entertain a motion to accept the minutes either individually or collectively, however one would like to proceed. I know we've done it both ways. Do we have a motion? Let's start with November 5th.
Mr. Chair, I'll make a motion that we approve both sets of minutes.
Okay, Sheriff Anderson, motion on the floor to approve both sets of minutes, November 5 and November 18. Do I have a second for that motion?
I'll second.
I heard a second.
Oh,
Okay, I think that, okay, there we go. Any discussion, edits, changes, etc.? Okay, hearing none. The vote is up. Okay, it looks like, and I don't know if we have any lingering from the chat that need to vote that way. Lindsay, are we good? It looks like we're good. Okay, motion has passed. The minutes have been approved. Moving to the next item on the agenda.
Excuse me, Bill. Sorry,
sorry.
Chair. I have a question about the voting. I'm seeing that non-council members are voting, and I'm wondering if that's appropriate or not.
I think, Lindsay, maybe you could describe that. I think that's recorded in there, but that's not counted in the vote, is it?
No, just so the not a council member, if you're not a council member, the responses should reflect that. So the 11, not a council member. If you're voting as a council member, you'd be selecting the yes or no, and that goes towards the quorum, as is the votes in the chat.
Thank you very much.
Thank you. I'm sorry, I saw your hand up. I thought maybe you were voting with your hand.
It wouldn't let people get rid of the vote screen unless they actually voted, so that's why the third option there now.
All right, thank you, Lindsay. We're getting better at the technology. Moving on to the next item on the agenda, the Executive Director updates. I will turn the floor over to Executive Director Chris Brickell.
Thank you, Chair. I'm going to try to keep my updates kind of minimal because we've got a lot on the agenda today. So I'm going to start with the class of the 120th. As you know, we just graduated last week, the day before Thanksgiving, 29 new law enforcement professionals. We had a nice ceremony here in a newly designed format in the gym, which seemed to work a little bit better for flow and time. It was good to see a lot of law enforcement in attendance at the graduation, as well as in addition to council members. The graduates worked hard to achieve their certifications, and that said, none of them would have been able to achieve those certifications without the dedication and the expertise of the volunteer instructors that give of their time and their agencies who allow them to do so. So we're continually appreciative of those efforts. And last but not least is really the dedication of the staff here at the VPA who manage in between those daily classroom instruction, all of the classes struggles, their successes and their difficulties, and also manage the constant communication between our staff and the agencies who have recruits here, which is really paramount to their success. So big thank you to the staff as well for this successful class that just graduated. Quick update on IADLIST. We just received yesterday the level 3 curriculum draft process for juvenile law. That is out for review for the curriculum advisory group. And their feedback is due back by December 16th for any actionable changes. Even if any of those changes are not actionable, general comments are welcome for them to review as well. Moving on to canine, we did not, as I mentioned at the last meeting, we did not identify a candidate for the canine head trainer position that we had advertised for. We were just lacking some of the necessary requirements to fulfill that position. So in an effort to make sure that we were continuing with the successes that we have now, we extended our canine contract for continuity's sake, as well as us seeing the continued success of the program. We can't leave agencies who have newly trained canine teams or those seeking to create new ones out there with no path forward. So we see the stability in the training that we're getting now, but more importantly, we're seeing the results and the successes of the program. So we're going to continue with that until such time as a permanent position replacement can be hired for that position. So our canine contract will continue for now. And I attended with both Lindsay and Vagar yesterday the Chiefs and Sheriffs Conference, which was held at Norwich University. We were prepared to give a presentation on Act 56 related concerns, as well as updates on ACADIS, our RMS system, and an update to the NTN entrance testing. When we arrived to a burst pipe in the ceiling in their conference room, and unbeknownst to us prior to our arrival, they had decided to cancel the afternoon content, which is where we were scheduled to present. That said, we did have a chance to connect with some leadership, and Lindsay was able to answer some individual questions from agency heads on ACADIS, so it was still time well spent. We got to see some new faces and some old friendly faces as well, and we plan to hold a virtual meeting after the first of the year with both chiefs and sheriffs. But I just want to remind all of those folks that were always just a phone call or an email away if there are concerns that they're not getting addressed. And then lastly, from me, while we have moved ahead with NTN for the entrance testing, we're still hearing occasionally some concerns about folks that either aren't able to sign up to take the proctored test, or they're having a problem with programs running in the background on the device that they're using, which is creating problems. So our ability to manage that is to try to minimize whatever those issues are. We continually work with NTN, but as a result, we are going to, after the first of the year, offer on-site testing here for folks that will be able to proctor up to 30. We'll do that monthly. And when we have that set up, which should probably be by the end of next week, it'll be advertised on our website as to when those dates and times are. But this is just really information for agency heads out there to know that if they have potential applicants who have either not successfully been able to log on and take the proctored test, or they have someone close by or that would rather travel here to the academy, we'll make that available after the first of the year. So just to let them know. And also, as one more reminder, last time that beginning the first of the year, that both entrance testing and PTE testing are requirements that will be in place for all level 2 and level 3 classes after January 1. So that is the extent of my updates, Chair, unless anybody has any feedback or questions on that.
Okay. Thank you, Chris. I don't see any at the moment. So and I'm sure, again, if there are any questions in the items that Chris reviewed that you think of later, they'll be happy to address them at the academy. Moving on to the next item, we have a Rule 8B waiver request for entry requirement. I will turn that back over to Director Brickell again.
Thank you, Chair. This is really a waiver request that we received. So Rule 8B of the council rules allows for the council to waive any requirement of these rules if the individual requesting the waiver demonstrates to the council's satisfaction that an alternative method will provide equal or greater support for the purposes of these rules and the council's enabling legislation. The reason that I'm bringing this up to the council is that there is an agency who has an applicant that they would like to register for the next full-time upcoming class. Part of the entrance requirements to register somebody is that you meet the minimum requirements, which are age 18, as well as having a high school diploma or a GED certificate. This applicant that you should have the documentation on, and the applicant is coming from Essex Police Department. His name is Almir Ismerlik. Hope I didn't ruin that pronunciation. But this applicant has had a hard time actually being able to produce a high school diploma. The reason for that is that he graduated from high school in Berlin, Germany in 1996 as a refugee from Bosnia. And that school had since closed and was reopened as a new school under a new name, and they don't have any records from the previous school. So there was some other documentation that was presented to us about jobs that this person had had, and they wouldn't have been able to have that without a high school application or a high school diploma. And we also received an affidavit under the pains and penalties of perjury that this applicant swears that they did receive a program which was the equivalent of a United States high school 12th grade diploma. So I was asking for this Rule 8B waiver for the council to approve this applicant to get into the entrance of the next full-time class.
Yeah, thank you, Chris. Are there any questions for that? We had the information in the packet. Any questions for Chris? Butch?
Thank you, Mr. Chair. Pretty nitpicky, but I'm wondering on the second page of the information we have, under the notary acknowledgement, if under the acknowledgement piece, there's a typo in it that says the city of Hingham, county of Plymouth, in the state of Vermont. I don't think the county of Plymouth is in the state of Vermont, and I'm not sure if that's an issue or just an oversight.
Mr. Director?
That's a good question. I didn't even notice that, and I'm wondering what state. I don't even see that this is listed as, oh, it does say state of Vermont. I'm sorry.
The stamp,
Yep,
the stamp does say in
Massachusetts.
Massachusetts, yes.
Yeah. I don't know the drafter of the affidavit form, so I can't honestly answer that for you. But you're correct, the stamp does say Massachusetts. Would it be feasible, should we be able to correct the affidavit, that we would be able to have a council vote on the applicant and the acceptance, pending the satisfaction of us receiving a valid seal from a notary? I don't want to get nitpicky about the legalities of that, so since I'll leave that up to the chair and council members to decide.
Yes.
I guess I wonder, maybe we should check with Chris Perkett on the legality of this, because a notary stamp means something. And I'm sure the notary would not want to sign an incorrect form. And I'm happy to make a motion to accept this application based on a corrected notary acknowledgement, but I'm not sure where we go with that.
Yeah, that sounds reasonable. It looks like, and I guess my question is, was that form, who prepared that form? Was that prepared by the department, police department? Essex? Do we
My
know?
assumption that would have been submitted to us by the police department, yes.
Okay. My suspicion is that they used another form and they didn't make the proper edits.
Yeah.
For a notary piece, and they didn't take Vermont out, which is probably mostly where it would be. So having said that, I think Butch provided some language for a provisional acceptance, if I can remember what it was.
Mr. Chair,
Exactly.
I would move to accept the application of the applicant Almir Ismaili, under the condition that a corrected notary acknowledgement be provided to the council.
Okay, so moved.
Trevor will second.
Okay, and we have a second on that. Okay, any further discussion? Okay, great. Then the poll is up. And I think we probably have, waiting to see what Lindsay has there. Have we passed the motion, Lindsay? Okay. By the quorum of the council, we have passed the motion, and we'll see what happens to get that in. And I guess Chris, you could probably report back to us when that loop's closed at the next meeting, so that we know the status of that.
Can certainly do that.
Okay, great. Thank you. Moving to the next agenda item, we have the FIP policy report. As you recalled, we discussed this at the November meeting and had a presentation from the committee about that. We were not able to vote on that report because we had not previously warned it as an action item. And so it was moved to this December agenda for that purpose. Upon discussion, the executive director and I have talked about this, and the nature of the requirement is that the policy needs to be reviewed, not necessarily redone every 2 years. And with that in mind, I'm thinking of a potential motion on this and let me get some language that I've been thinking about here, to accept the review and recommendation of the FIP subcommittee to maintain the FIP policy currently in place. I think that's what we're doing. Daniel, I'll look at Daniel on that. And any comment on that, Daniel?
No, that sounds accurate. Just voting to accept the report that we spent a lot of time on, and Kim in particular, and Lisa. So that sounds great. Thank you.
So we'd be accepting, just so that we're all clear, we'd be accepting the report and the recommendation to maintain the policy. Lisa.
Good morning. Thank you, Chair Clements. I just wanted to add a note that we do need to add to the report Wesley Butler. He was inadvertently left off as a subcommittee member. So I don't know if that needs to be like an amendment or anything, but I just wanted to mention that. Thank you.
Okay. We'll take that as a friendly addition to the revised edition of the report, the addition of that name. Major Peterson.
I believe we actually accepted the report at the last meeting. I think we need to vote. I think the only thing we need to do in this meeting is vote on the recommendation of the report, as you described, Chair, to maintain the current policy. I don't know that we need to vote again to accept the report.
Yeah, my concern was that we have the comprehensive language in there specifying, as per the requirement, that we have reviewed and will accept that recommendation all in one place, because we didn't act last time. We didn't have and thanks to Butch for pointing this out, we hadn't properly warned the action. So I'd like to be sure that we have that all comprehensively in a properly warned action. I understand what you said.
Understood. I agree.
Do we have any further comment from the committee? I think I'd like to do the motion, but then I'd like to have a discussion about kind of what's next, because there were some potential actions for the committee to take, and maybe if there was some feeling the council had about pointing the group, the committee, in a direction for any priorities for next year. But let's stick to the motion at the moment. Do I have that? Would you like me to repeat it? I need somebody to offer it. The motion would be to accept the review and recommendation of the FIP subcommittee to maintain the FIP policy currently in place.
Chair, I'll make that motion.
Okay, thank you. Major Peterson. Second?
I can second that.
Okay, thank you, Karen. Any further discussion? Okay, I'm looking at Lindsay. We're ready for the vote. There it comes. It's coming up. There we go. for the thumbs up when we've got the vote in from the council. Okay, you got the thumbs up from Lindsay. The motion has passed, and thank the committee again for their work. I'd like to provide the opportunity if there are any council members that have, in particular, there were several options for the committee to move ahead on page 4 and 5 of that report. If there are any preferences folks had about what would be a priority there. This is an opportunity to do it, or simply to communicate with the subcommittee. I know they'll be continuing to work on this and following up on many of those notes put in that report. My observation was they all look good. Just do them all. I think we have plenty of direction for the ongoing review and the continued review of the policy. So again, I'd like to thank the committee for their work on this. And okay, it's an ongoing piece, and I think everybody knows, that Daniel and Lisa on staff and the rest of the subcommittee and Karen, who I have on my screen here, I'm not neglecting others, but they're available for input on this as we continue to move forward. Okay, thank you very much. I'm going to turn the floor over for an introduction by the executive director on the K-9 standards element here, and then I think we're going to have presentation by Richard Slusser. Chris?
Thank you, Chair. Excuse me. What I wanted to do was bring back before the council another edition of approved, or not approved, but a new rendition of K-9 standards that we're hoping the council will take a look at and give their blessing to. As you might recall, a number of years ago, the K-9 standards were really overhauled following some outdated language, practices that were not really buried in science. And when that overhaul was done, it was to meet legal obligations as well as following best national standards at the time, as well as adding NESPAC standards, which is what basically most of these K-9 standards are modeled after. One of the things that we were going through once the last version of the K-9 standards were approved by the council is that there was continual meetings by the K-9 subcommittee as well as the head trainer on the realities and the practical applications of the standards once they're put into place. And so a lot of these changes I'm going to summarize by they're modified simply by either time requirements that are needed or how many days might be needed for retraining or recertification, and that should be based on what the head trainer sees and observes and how quickly that K-9 team can get to that transition point. So we're modifying a lot of the things that were written into the standards to what the actual application applies to in real life circumstances. So in these standards, those are the majority of the changes, with the one caveat that there is an addition right on page 2 of a section that basically outlines that the K-9 committee will review these standards on a recurring basis to ensure that they align with operational needs and program requirements, and that any modifications of the standards shall constitute operational changes and shall become effective immediately upon implementation. The rationale behind that is so that when there are recognized changes that need to be made, that the K-9 subcommittee and the head trainer can operationalize those without having to wait for another council. Sorry.
Yeah, could we go on mute, please? Whoever the background noise there. Okay, thank you, Chris.
Yep. So getting back to that one section on page 2, it's to make sure that when there are observations that are made of changes that need to be modified in the standards for, applicable reasons, that they can be operationalized before having to bring another set of standards be reviewed by the council and have them approved. So when there's something that we see that needs to be modified, it can be modified, and we'll modify that. And the next time that there's an approval that needs to come before the council on the entire standards, that we bring that to the council again. It just keeps them from things that seem to make sense to be able to do and operationalize for the benefit of the program, rather than waiting for or bringing to the council each time a simple modification that needs to be done in the standards. So again, this is really a correction of operational things, still following best practices, still following NESPAC standards, with the exception of the larger section towards the end of the K-9 standards, which is why I asked Rich to come on and just address that section on firearms. And it makes sense to me. And as it was explained to me, it makes sense. But because it's so comprehensive looking a change, I wanted him to be able to provide the rationale behind why that change was put into these standards and why it makes sense to do that. So having said that, I will turn this portion over to Rich so that he can bring to you the firearms change.
Thanks, Director. Morning, everybody. Can you hear me? Perfect. Yeah, we just updated. It's called GSR, gunshot residue. It's for firearms, dogs. It's relatively a new type of standard. Our old one was called powder dogs, which is more in line with, say, a bomb dog. It's unburnt powder. This is burnt powder. So it finds shell casings that the game wardens use a lot, and firearms. So this is probably 95% taken from the NESPAC standard as well. We took out a couple things like crowd screening. We don't need dogs to be searching people, anything like that. And also with the intention, our certifications are basically patrol, we have tracking, and then detection. In the old days, we had everything listed under detection, like cadaver dogs, bomb dogs, accelerant dogs, whatever. So we wanted to slimline that all down to detection. So what we did is these GSR dogs now they do the same detection test as the narcotics dogs. It just makes everything the same and equal throughout all the disciplines. So the old one, like I said, like a GSR dog would be burnt powder. The old one would have black powder. A real GSR dog won't find the primitive black powder. That's just an example. And these were, like I said, taken from NESPAC, and it's what the national norms are. So that's why we went with these.
Right. Do we have questions from the council about those changes? Either what Chris had mentioned early on about the process for ongoing review by the committee, and in particular the firearms reformulation in the policy. I'm not seeing any. Any other observations, Chris, on this?
None for me.
Or
Just
Rich?
that this is an ongoing learning experience for me, and each time I attend their meetings and hear the explanations and the rationale of how they do what they do, it becomes clear to me each time. So I would encourage anybody that has an interest in canine training to attend one of their meetings. You learn a lot.
So I think the important thing that I heard there on the particularly on the gunshot residue in that section on detection was the alignment with the NESPAC standards. So it sounds like it's pretty much aligned in all the relevant areas, at least for the training that that happens in deployment that happens in Vermont. Would that be correct, Rich?
Yes, that's correct. We made it specific to Vermont though as well. So like some of the states, Connecticut, Massachusetts, the dogs will be a probable cause dog. Up here, the regulations on guns are quite different, so it's considered an administrative alert dog. So it's 95 or higher percent NESPAC, and then little tweaks for Vermont specific like that, the admin alert.
Okay, great. You're right. Well, it's a complicated area, and I don't profess to be an expert in dog training, so I can understand the the nuances and the evolution of the training and the need for the committee to continually be looking at those practices and to keep them current and in alignment with best practice, and particularly in the region with NESPAC. So, okay. Any other questions? I think that we could move if there are none. I would entertain a motion to adopt the revised canine standards.
I'll make a motion to adopt the revised canine standards.
Okay, thank you, Karen. Do we have a second on that?
Yeah, I'll second it.
Okay, Daniel. Thank you, Daniel. Any further discussion or questions for Rich or Chris? Okay, now hearing none, I hope I'm not too far ahead of Lindsay. I think we're ready to vote. There we go. There's the motion to accept the updated canine standards. Okay, I see Robert Stebbins has got the thumbs up. Visual vote. Probably there. I'll wait for the thumbs up from Lindsay. Okay, we have the thumbs up. Thank you very much. The motion has passed. Thank you, Rich, for preparing that update and briefing us on that change, particularly at the end, the bigger section there.
Thank you, sir.
All right. The next item on the agenda, I think, is an easy one. That's the council schedule for 2026. Chris, do you have any further updates? I think we all received that. There's nothing radically changed. It puts the general monthly meeting of the council on the first Wednesday of the month, and the special hearing dates set aside for the third Tuesday of each month. No changes there. Anything notable, Chris, that we should be aware of?
You done it, Chair. There's nothing else for me to say. That's the new calendar
Yeah.
dates.
Nothing further to say. Any questions from the council on the calendar before we move? I didn't think there would be. I'll entertain a motion to adopt the 2026 calendar as previously distributed.
So moved. Anderson.
So moved by Sheriff Anderson. I'll take a second, please. Kelly.
Second.
Okay, Kelly got it. Was that a second or was that a question?
Yeah, no, it's a second.
Okay. Second from Kelly. Any further discussion on the calendar? Hearing none. Lindsay's ahead of me this time. Okay. Motion is up. Pretty non-controversial item. Easy one. Wait for the thumbs up. Yes, we have a thumbs up from Robert Stebbins on the vote. Okay, we got it. All right, thank you very much. Our calendar has been adopted. I'll point out that I'll have to say that when I was first looking at coming onto the council, I thought, boy, that's an awful lot of meetings. Why does this council have that many meetings? I've now since realized we have a lot to do. So there really is that need for the monthly meeting, and I'm glad we do it because I think statutorily we're only required to meet quarterly. That would provide kind of a gap, in my view, a gap in continuity and flow of the council on items that need to be tended to in a timely manner, and certainly just the general, I guess, not inertia, but the movement of the council and working together in various directions. So, thank you. That motion has been adopted. I will turn to Executive Director Brickell, or I'm sorry, yeah, well, I'll start with Chris on the indefinite waiver report out, and we can go on to the next agenda item. Chris, do you have any comments on that before we are briefed on it?
I don't, Chair. We can go right to Sergeant Hodges if she is prepared to give the report out from that committee.
Great, thank you.
Good morning, everyone. So the language was attached, so if you have questions, certainly feel free. I'll try to keep this pretty brief, but as of beginning of 25, indefinite waivers became requested mainly through like A-RIDE, and with the mandate that everybody must have it after 3 years of graduating from the academy. So from February 5th onward, the waiver subcommittees met 7 times to review numerous requests from agencies coming in. Part of that request was to provide job descriptions and what folks were doing so that we could better assess those requests as they come in. So we received 107 requests from agencies. 101 of those were approved, meaning they received an indefinite waiver and were not required to complete A-RIDE given their current duties, their current job obligations. 6 of those were denied. So as the committee, we felt their current job duty would have potentially some correlation or some connection to traffic, and therefore they may potentially need that A-RIDE option. So those 6 were denied. Language was provided to agencies, excuse me, Lindsay, correct me, it may have gone direct to the applicant requesting it, not necessarily just the agency.
Agency and applicant, yes.
Perfect. So if they were approved for that waiver, they were told, you have this waiver, should your job duties change, it is on you to revisit that waiver request, to seek it again from the academy going forward. And then, yeah, so the language specifically said if at any time the position or job duties change, the indefinite waiver will be void. At that time, a new request would have to be submitted or the A-RIDE class would need to be taken. So that's the specific language that was sent to agencies and the applicant. And so that's kind of the gist of what our report out is for the indefinite waivers.
I had a question that I think you could help me understand. How would what triggers a notification that to the committee that the job duties have changed? Is it how would you know?
So that would be
self-reported.
It would need to be self-reported unless they have, unless the academy has a tracking option in a CADIS, but mostly it was put back on the agency and the applicant, given that language, to be adults and notify us when the job changes.
Mark Anderson, your hands up.
Yeah, I would just also follow up on Sergeant Hodges' response that some of this is the duty of the officer, and if they're acting outside of their authority, they are likely committing a Category C violation, which I would refer to the Professional Regulations Subcommittee. So some of this is to use existing tools and structures, and that was part of the committee's discussion, is how do we enforce this with the resources we have.
Jamie.
Hi, as the impaired driving training coordinator with these indefinite waivers, is there any language that goes to them if they have a second job that the indefinite waiver does not apply to them, like a part-time position at a different department?
So we did talk about that in the committee. And I'm trying to think now, Sheriff Anderson, maybe you remember what some of that conversation was. I know we were trying to figure out if it would go specifically to that individual or to the job itself. So if they request a waiver with agency A, right, that waiver goes with agency A. If they have a second job and they're working for agency B and they're doing something there, then they would either need to request that waiver with agency B or attend and complete a ride. I have that accurate there, Sheriff?
That was one thread of the conversation, and I'd want to go look at our minutes. I think we said the waivers against the certification, so it's on the officer, and if they were granted a waiver from agency A to B, it's the officer's responsibility to say, these are my obligations and responsibilities. Again, it's their scope of practice, it's their authority under their certification. I think that's where we landed, but I would want to review, because everything you just said was also what we said.
Yes, you are both correct. We did land on it as the officer's responsibility. It is their certification. It's not a certification to the agency. So they technically, if they're applying for a indefinite waiver for a ride, because in one department they're not doing any of that road work, but in the other department they should not be requesting it to begin with. But it would void. So if they're working for multiple departments and they're doing patrol work in the other department, they need to notify both of their agencies. I have applied for an indefinite waiver, so they either need to be on the same page of either they're not doing patrol work, or if they've been granted, or if they're not granted the indefinite waiver because they are doing patrol work for one of those agencies.
Is the waiver committee being notified when they're working for two different agencies?
That's through ACADIS. So unless they are sharing their employment, so all that is reflected whenever there's an employment change and people are working for multiple agencies, we'd be able to see that on our end. It's still incumbent on them though in their certification.
I have been notified that multiple people have been authorized of these indefinite waivers, but they work for multiple agencies and don't know that they can't, that it doesn't apply to both agencies.
It just applies to their certification, not the agency itself. So it's for their personal certification.
So maybe they shouldn't have been
work.
Provided the indefinite waivers because they work for another agency where they do perform the traffic work. But if the waiver committee doesn't know about that, then they're getting approved, the officers actually believe that they're okay, they're because they have the waiver, but they're not.
Right,
So-
that waiver, when they were granted that waiver, it was through that one department. So if they're working for multiple departments, that technically is for their certification at that department. But correct, if they're working for multiple departments and say they're working for 3 and 2 of them, they have, they're doing patrol work, then they're at risk for a category C violation because they're doing what is required for an A-ride indefinite waiver. So any of those you can report to us.
Yeah, thank you, Lindsay. When the waiver is granted, how is that communicated? How are those conditions communicated?
Those are to the agency head and the officer.
And I'm particular about should they work for another department? Is that clear in what they receive, what that officer receives, awarding the waiver? Is it clear that this waiver only pertains to your duties in this department? Should your duties shift in another department, you would be required to seek the appropriate training.
I will look back at what that communication looked like to confirm. I believe I also sent out follow-up communication regarding that, but I will double check just to make sure that clarity exists.
I think that would be good just for the sake of the council to understand this process. Maybe at the next meeting that we could get a report back on that, so we have some clarity on how that works. I believe it does. I mean, I'm happy that there's the professional regulation element to it that would require, that's kind of that oversight provision that would require that certification be attained. But I also want to be clear that it's being communicated clearly as to what those conditions are. I think some of the issues Jamie pointed out that particularly with many departments, being short and somebody might be picking up hours at another department, that they're fully aware of what that waiver pertains to. Sheriff Anderson, you had your hand up earlier.
I'm certainly content with the direction that you've suggested, Chair. I was just going to say, having applied for waivers on behalf of people at my agency, there's a clear specification to the officer who's receiving the waiver. These are the conditions which revoke or void the waiver. And so I do believe, because this was a point of concern with the waiver committee in granting these, what causes it, what creates the notification, what puts a person into a position of responsibility if we're talking about category C conduct. And so we were intentional on that. It's not to say we exacted it exactly as we desired, but I think we did. And if there is feedback on it, I'm sure when that information comes back at next meeting, we can really iron out any concerns people have. But this was very much intentional.
Okay.
Thank you both.
Thank you. Yeah, thank you very much. I think it clarified it for us. And we'll just look for at the next meeting, just an update on what that communication looks like, so the council can be assured that the applicability of the waiver is clearly communicated to the individual receiving it for their certification. Okay. Are there any further questions for Sergeant Hodges? Great. Well, thank you. Thank you for the report and the update and educating us a little further as a council on how that process works and what the nature of the waiver is and its applicability.
Absolutely. Thank you, sir.
Okay. Thank you. Moving on to the next item on the agenda. We have a couple of related items, but the draft procedure for 20 VSA 2359. I'll turn it over to Chris Brickell and Chris Burkett to brief us on that. We received some information and background in a memo from Councilor Burkett. I'll turn the floor over to you gentlemen.
Thank you, Chair. I'll probably directly turn it over to Chris Burkett, but this really comes out of our state auditor's report back a few years ago, when the statute requires that we have some sort of sanction for agencies that don't become compliant with statewide mandated policies. And while there has never been a sanction taken against an agency where we have denied them services of the academy, we knew that that was something that we had to come up with a procedure based on the report from the auditor's office. And then after review of that and the language in that, our counsel, Chris Burkett, had a review of that and felt the need that there really needs to be a different process than what was recommended from the auditor's office. So I'll let him speak to that and the draft language that he's written up so that the council can take a review of that.
Thank you, Director, and good morning, Council. I was asked to take a look at the auditor's report that we received a follow-up from just this past September, and they noted correctly that we had not implemented something that we're required to do by statute. The statute is 20 VSA section 2359, which indicates that on or after January 1st of 2022, law enforcement agencies can be prohibited from using VPA and council services if they're not in compliance with certain requirements, and that we are to adopt procedures at that time, and we hadn't done it yet. Looking at that, we talked internally at the VPA about whether or not a procedure or whether a rule was more appropriate. And in looking at the two, it would appear to me that as legal counsel, that what we really want to have is we would want through formal rulemaking to have a rule that provides the outside agencies an opportunity to essentially argue their case before the full council. It also gives them appeal rights, so that we're not just imposing an internal procedure on outside agencies in a way that doesn't permit them to have due process. So what the memo that you've received has in it is both a proposed procedure and a proposed rule that we will be proposing to the Rules Committee for hopefully formal rulemaking in 2026. And the procedure is there as a stopgap and essentially to alert outside agencies that may or may not be part of the council or may not, necessarily always timely get information about the council, that basically that the rule is coming. So that's why we have an interim proposed procedure as well as a draft of a proposed rule for rulemaking. And I'm happy to answer questions about either.
Thank you, Chris. So just to summarize, again, to be in compliance with the auditor's earlier report, the rule, the proposed rule, or at least the draft proposed rule, that many of you are aware of, but for those that aren't, it's a rather lengthy process to go through the rulemaking process. So it's nothing that even if we voted today, this council could adopt without having gone through that and put into effect without having gone through that full process. And as I understand, again, summarizing the document you've provided, Chris, is the interim procedure, which when I reviewed that, it essentially parallels the rule. And if it doesn't, maybe you could explain where it might be different from the proposed rule for us. To bide us over while that rulemaking, the rule is being developed and then placed through the process. So ultimately, I believe before we go into the rule process, we would adopt, at least the council will have another cut at the rule if there are any changes in the draft prior to that submission. But for now, I think the important thing is to put the procedure in place, albeit interim, to provide the necessary coverage under that statutory requirement. Was that a fair summary, Chris?
I would say that's a fair summary, Chair.
Okay. Do we have questions from the council, and particularly the law enforcement community, on what's being proposed here? And what we would be voting, I believe we would be voting on, let me see if I have this correct. I'll turn to both the director and the council. That we would be voting on adopting the proposed interim procedure while the rule, in the context of the rule being developed and put into that process. Is that correct?
That's correct, Chair.
Chris,
I don't know if it matters. I don't know if it matters to you, Chair, whether or not to have, two separate motions, one to adopt the interim procedures as drafted, and then a second one to, formally adopt the process of going through rules to create the rule that is suggested that we need to have, or whether you want to condense them into one motion.
I'd be fine with having that be a singular motion if we have some adequate wording to capture that. But it might be cleaner to have a single motion to adopt the proposed interim procedure, and then a separate motion to move into the rulemaking process. Sheriff Anderson.
Mr. Chair, I make a motion to accept the interim procedures pending a future rule. I think that's it. I don't know.
Okay, I was waiting.
What Chris said.
Okay, so the motion language that Sheriff Anderson has proposed is to adopt the interim procedure pending adoption of a rule. Okay, I think we need a little more
sufficient. I'm open to a friendly amendment if Attorney Burkett has language he really cares for.
Yes,
I actually liked Sheriff Anderson's motion. I think it states with specificity what we're asking the council to do, which is adopt in the interim a procedure pending our rules committee forwarding and through formal rulemaking, a rule that may supersede it, which is legalese for exactly what Mark just said.
did you get that, Lindsay? Maybe. Um, uh, did you get something, Lindsay, out of that could you repeat to us?
Sorry, it blocks me out. Yes. I apologize. Adopt interim procedure pending a rule adoption or a revised
It's
rule
the
adoption.
motion would be to adopt the interim procedure, and I would inject relative to the requirements of 20 VSA 2359, so that it's very clear what we're adopting, pending creation of a rule.
I accept the friendly amendment.
Okay. I think that's pretty clear. That was well summarized in the document that Councilor Paquette had provided.
I second Sheriff Anderson's motion as amended.
Okay, Kelly, thank you. Well, that was fast.
Sorry.
It's up. Okay. We have the vote up. Wait, Lindsay's thumbs up or down? Looks like it's going to be thumbs up. Okay, we are there. We have adopted the motion, and I guess I should say let the rulemaking process begin, Chris. And what do we have for an estimate on how long do we think that will go through? I know that it's months, it's not weeks.
My hope is that we have the rule in place and effective by this time next year as a realistic thing. My optimistic, cockeyed optimism is that we have the rule all but signed off on by June. And that may be overly optimistic. This is my first round of this, so I'm pulling some of these just from looking at Kim McManus's old notes and kind of speculating a lot of it. But I will say the chair of the Rules Committee has made it clear that he wants to move forward quicker rather than slower. We have a preliminary meeting later on this month with a follow-up meeting that will happen in mid-January to go through all of the rule amendments that we know that we need to make to our council rules. So it's already in process.
Thank you. Okay, thanks, folks. We have a second, is that on the agenda, draft policy 20 VSA 2372? Was that really, did we just do that?
No,
Was it
that's
separate?
No.
That's separate.
Okay. Okay. Then I'll turn the floor back over to the director and council.
Again, I'll pass this right on to council because he's got everything prepared for you and it doesn't make sense for me to waste extra time.
So 20 VSA 2372 is a new statute that was passed by the legislature last year and obliges us by December the 15th to create a model policy regarding the use and access of sealed criminal history records by law enforcement professionals. This is more of a report out rather than an action item for the council, because while we do have a draft policy that is starting to make the rounds for comment, it is not in a final form that we can provide to the council for voting. My anticipation is getting that to the council hopefully by the middle of this month or towards the latter part of this month, but with enough time for us to review so that when we come in for our meeting in January, it will be an action item that we can vote on. And the policy is going to be fairly commonsensical. It's, these are records that have been sealed by a court. The statutes are clear as to what it is, that how we can access it, what we can access it for. So the idea is just create very clear in plain English definitions for officers so that there's no question. The only addition that might cause some hiccups and for which some education might be necessary as we roll this out is that the statute does require that law enforcement agencies keep a record of any access to those sealed criminal records. But again, it's not anything that law enforcement agencies haven't done with other things, so I don't anticipate a lot of hiccups here.
Okay, thank you. We'll look for that perhaps at the January meeting. All right. Any questions for Chris about that? Okay. Moving on to the next agenda item, 20 VSA 2358B2 B2. I'll turn that over to Chris Perkel. Again, this is not an action item. This is a briefing item.
Thank you, Chair. This is probably the most complicated, the one that will take the most time and input from council members. And as with everything that we discuss at the council, you can't start without going back in history to find out how we got where we're at. So my request was for this to be the beginning discussion of interested parties, especially within council members, on Title 20, 2358 2B2, which is a title in a section within Title 20 that allows for the addition of a scope of practice permitted for a law enforcement officer to practice additional areas outside of their scope of practice. So as everyone on the council knows, we have level 2, level 3 officers that we currently certify. Level 2 officers have a very specific scope of practice, and for the most part, it does not include or allow them to investigate any felonies. Why? Because currently they go through 2 weeks of training, then they come back and to their agency, they work through the FTO process, they come back here for some core classes, and then there are elective classes that they take within a year's time frame. Once they complete that 3-phase process, then they get their non-provisional level 2 certification, which allows them to do everything within the scope of practice that a level 2 officer can do. Why doesn't it give them level 3 certification? Because they haven't gone through the full-time academy. So they don't get the basis of knowledge of all of the base learning that they need to have to do everything that law enforcement is responsible for. It's a very truncated and shortened period of time. And because of that, the legislature felt the significant need to identify scope of practice. When they did that, however, going back in history, there were part-time officers who would be classified as level 2 that had been working for years. And back then, before scope of practice, there was no restriction on what a part-time officer could investigate or do. The only restriction was that they couldn't work beyond 30 hours within a week, and that was it. So level 2 or part-time people back then did and investigated all kinds of crimes, and they did it because they worked for years, and they also worked with full-time certified officers, and they got that level of experience. There were some, however, that just worked filling in vacations for people. That's all they did was traffic work, so they were happy to do that. The legislature said, no, we're going to have a scope of practice and make sure that we know what officers are certified to do. Having said that, what happened was when level 2 scope of practice came into play, we had to come up with some process for all of those officers that had already been doing good work and had a lot of experience. That's when the council created the level 2E process, which was a temporary transitional period to bring those officers that had experience into a process where they would come before the council. They would identify what they had been doing, show their training and their experience, had letters of recommendation. The council reviewed each of those officers individually. And if they were approved by the council granted them a very specific level 2E scope of practice, which gave them some additional scope of practice. And most of it was around people that were doing criminal investigations, sexual assault investigations, things of that nature. And they had experience that the council felt confident in acknowledging. The reason that process was in place is because the council realized that there had to be a transition from people already doing the work to the new legislative action. And in addition to that, they realized that this was only going to be a short-term temporary fix for people to get through that process. And now everybody that was going to be trained under the new level 2 process would have a defined scope of practice and nothing more. So that's how that process took place. And that process was sunsetted by vote of the council in 2019, I believe. So having said that, there still remains in statute this language that allows for an additional scope of practice to be authorized by the council if they so choose. And so because of that language, I have had an applicant who has reached out looking to get an additional scope of practice specific to being able to be employed working in an SIU, or sexual investigative unit, for those of the council that aren't familiar with that acronym. And what those units do is basically they investigate sexual assault crimes. A lot of them involve children, and these are felony cases that need very specific additional training to what somebody would get through in their full-time basic level 3 academy class. They would get all of the domestic violence, sexual violence training that they would that a level 3 gets. They would get the nuances of, courtroom testimony, the nuances of RFAs, all the types of court orders that full-time officers get trained on. And then in addition to that, interview and interrogation techniques and all of that training that goes into a level 3 that a level 2 just doesn't get in that very compressed time frame. Having said that, it doesn't make sense when you look at it at first face to say, why would we let a level 2 officer apply for and be granted an additional certification to investigate crimes like sexual assault on a minor? Like, that just doesn't make sense until you get an applicant that comes to you and says, I don't have full-time certification, but here's my background. Here are my letters of recommendation. Here are the trainings that I have taken since my level 2 certification that go to all of the things that you would hope that somebody would attain when they were going to work at an SIU. It's even additional training that you would hope that a level 3 officer would take in addition to enhance their investigatory skills and their reasoning. They're able to deal with victims and all the things that surround sexual assault investigations. So my real struggle with this is I wanted the council to hear the fact that there is an applicant that has applied that does have some very necessary background, additional training skills, has letters of recommendation from those that are supportive, those that manage SIUs, state's attorneys backing. So there is certainly the support for an applicant. The question that I really have for the council is, how do we take these and do we continue to take them simply because it says it in statute? We've had a lot of addresses dealing with subcommittees on an alternative pathway. And what does that look like? And do we have a pathway that somebody can get into that we can design that will move them from a level 2 to a level 3? That's the recommendation that this council heard from the alternate pathways subcommittee. And so I feel like because there are varying different agencies that sit on the council and varying different opinions and degrees of rationale that should have a voice in this decision, that it's not simply all of a sudden I have somebody that comes to me and says, hey, this is in statute. I want this additional certification. How do I get it? And there is not a process for that. And I don't think it should be just a process that says a switch on or off. There should be individual thought processes that go to it. So that was the beginning of the discussion point that I felt like, certain members of this council may want to weigh in on. We, prior to the alternate pathways subcommittee coming to their report that they submitted to the council, we have had one level 2E officer that has made the transition from level 2E to a level 3. That was an arduous process. It was created by a lot of training documents that officer submitted to us. It required him to come back to numerous training events here at the academy to reach things that he did not get because he did not attend a full-time basic academy class. Even though he'd been doing the work out in the field for years, this was a process that both chiefs and sheriffs sat in on to determine what is that process that would make this legitimate for this person to receive a level 3 certification without going to the academy. That person completed that process and is now working in the field, but it's been one person and only one person that has applied and successfully completed that process. So this one is a little bit different. This applicant isn't looking for a full level 3 certification by another means. They're looking for a caveat carve out to be able to work in an SIU and investigate felony crimes around sexual issues and involving incredible victimization that we don't want to make any kind of bad moves on. So I think I'll stop there and just leave that open for any questions or other input from other council members on their thoughts on the fact that this is in statute and whether or not there should be a process for folks that singularly reach out for one specific carve out.
Thank you, Chris. Sheriff Anderson, you're first in.
I appreciate the director's explanation of the history because it lays out some of what of where we are. There's a logistical issue here in terms of what resources the academy has or doesn't have to manage this. I can come at this with philosophical. We can talk about one-offs. Like we could spend hours on this one topic, and probably most of us won't agree on anything. So I'm going to skip most of it. Other than to say, if I guess to answer the director's question, if should we accept these because the statute says we need to do this, I think we should. And I don't think that that necessarily means that we say yes, but the statute does say we should be, as a council, capable of having the conversation and determine what is or is not. And I think that we should embrace that empowerment by the legislature to say, we know the profession better. It might be we codify rule or a procedure that says, generally speaking, these one-off things, we don't have the resources to manage. And so we're not going to allow our process to say, well, Officer Snuffy, you have a unique skill set where we're going to allow it, and therefore you are blessed with this one certification that nobody knows or understands about. The flip side to that, though, is that I think we can come at this from a systems perspective to say we have training which we understand better than what the legislature was able to codify when they passed the statute, which is why I believe in part they did empower the council to recognize it. The scenario I use frequently is DUI 3. There's no difference on a DUI investigation from a DUI 2 to a DUI 3, except that the criminal record itself says the person has 2 prior convictions, which level 2 officers do have the training to do. There are other things where law enforcement are called to, which would be considered outside of the scope of practice of a level 2 officer, that level 3 officers routinely say they are not responding to at all. I would rather have a terrible investigation performed than a refusal to perform an investigation simply on the basis that we did not provide sufficient training. So those are personal opinions of Mark, but at the end of the day, I think that we have the ability to look at some of these things and say, what is better for Vermont within the abilities that we have? I fully understand and would agree and concur with several others saying a DUI investigation with a death resulting, a level 2, has no ability to conduct a full investigation on because they don't have the training about it. And so there are clear, definitive lines that we can establish. I think if we can come at them with the legislature's empowerment to say within these training curricula, we are capable of establishing these higher levels. Can a level 2 officer perform a sex assault investigation? Probably not. They don't have the training. But can they be participative in the SIU model? In some counties, that is generally done with non-law enforcement forensic interviewers who have masters in psychology that law enforcement don't even have. I've seen skilled interviewers who have no law enforcement credentials capable of doing a better interview than I can, which embrace trauma-informed practices, not re-victimizing people. It's based on scientific, data-driven analysis of a variety of these crimes. I don't know that I come with necessarily an ask or a statement of fact other than what I've said, but I think that this is within our wheelhouse. I think we do have the ability to establish ways that we can embrace the law enforcement profession, including the level 2, but also fully understanding the concern that the director brings forward, saying, how do we deal with this on the logistics, but also on a common sense practicality? Have they been trained to do the things that the public would generally expect of them? I think those are areas anyone could agree. So thank you.
Okay, thank you, Sheriff Anderson. Robert Stebbins, please.
Thank you, Mr. Chairman. The only thing I would add to Sheriff Anderson's comment is my agreement that logistically, if we do this too many times or there are too many requests, you could theoretically almost morph this council into a full-time job. And I think it should really be a extremely, extremely rare exception. And I would point out that in order to be a doctor and practice medicine, there aren't too many exceptions there. If you look in Vermont, or the practice of law, not too many exceptions. It's quite rare. Most of the time when you stand up in front of a judge, you're a lawyer. And I've never seen it in my career where a judge has said, yeah, you don't have to be a lawyer. Come on up and you can represent your client and, you've been through a year of law school. I know you can do if you're partway to getting the bar exam passed. However, it's, I think, not a standard practice. So I think my only input into this would be that we move very, very slowly on this and just make sure that it doesn't get to the point where 15 or 20 folks are jumping on the bandwagon and inundating Mr. Brickell with requests for exceptions. I think if it gets to that point, it's easier to just go through the full-time academy or the level 3 academy and just get that done with, as opposed to spending an inordinate amount of time looking at individual requests. And thank you, Mr. Chair.
Karen.
Thank you, Mr. Chair. I want to express my agreement with Sheriff Anderson and Mr. Stebbins. It seems to me that there's a couple things that I think we should be really considering in these requests. One of them is the standardization of how you make a request. And I think that I agree with Sheriff Anderson. I'm going to mark this day on the calendar. That there is, the legislature tells us that we have to do this, we have to do it, unless we want to change that law. So it makes sense to me for us to figure out a way that for these requests to come in that includes a transparent process and a really robust set of criteria that those that are applying for these exceptions would have to comply with. I agree. I think that I think that we have level 1, level 2 and level 3 certifications for a reason. And I don't see very many opportunities for us or reasons for us to consider advancing somebody with a level 2 into a role that could be pretty compromising. I'm thinking about legal liability and prosecutorial, the potential for prosecutorial success. I can imagine being a defense attorney and going to court and saying, well, Sheriff Anderson or Officer Anderson is this level 2 and did this investigation, but really isn't, qualified to be able to conduct this investigation. So we should just get rid of these charges. I think that I think it makes sense for the decision-making to be the locus of decision-making about these requests to be someplace that would include, I mean, I don't know, I don't want to make more work for the professional regulation subcommittee, which, by the way, Mr. Stebbins is actually a full-time job. I think that it would make sense for the decision to not have to necessarily sit with the director, because then we can make it transparent. I'm not saying anything, not casting aspersions on you, Chris, but we can make it transparent, we can make it standardized, and we can make really good decisions, I think, if there's more of a group decision-making process. My 2 cents. Thank you.
Thank you, Karen. Butch.
Thank you, Mr. Chair. I have a question for Director Brickell. Chris, why, do you know why in 2019, first of all, do you know why the council voted to sunset the provisions that you had to comply with 20 VSA 23 et al.?
Yeah, I believe that the reason and the rationale behind it was because the council recognized that when this transition from part-time, full-time to level 2, level 3 was taking place, it was now going to limit people that had been doing work for years and take away from them things that they did and did well. And so it made sense for the council to, because of that section in law, to be able to say, let's look at those individuals that are really doing that extensive work, have them apply to the council, show us through, actions and, prior affidavits and search warrants that they had written and recommendations and casework that they had done, that they can actually do the work and that they have been doing it. When the council looked at those and they voted, one way or the other, and there were some that didn't get that additional sanction. But once the council did approve it, they got that special certification of the level 2E. The rationale between sunsetting it was that there's only so many people that fit that criteria, and there's only so many people that are going to want to continue to do that work and or not come back through a full-time academy class. So they let it go on for a couple of years, and then by council vote said there's nobody else applying for this. It doesn't make sense to continue it. We're going to now sunset this process so that it no longer exists, because they didn't want to see, I believe, this come up now and have to deal with it in the future or have specific requests for very specific things.
So
that's the best explanation I can give you.
Okay, thanks. So this statute's been on the books for quite some time. Has there been any modifications to the statute that you know of?
None that I'm aware of in this. No.
So the council has decided by sunsetting it that we're just not going to do this. And even though this is still on the books, so should the council consider, after a long period of study and taking a look at it just goes very slowly, say that the council says, no, we are not going to do what's demanded in the statutes, then do we ask for a repeal of that section of law?
All good points. This is why I bring this stuff up. Like, is this discussion for, is the law applicable and does it make sense? Should it be revised? I don't want to offer a suggestion because, there are arguments that you can make both ways. For instance, and I don't say this to muddy the waters, but somebody who goes through full-time basic training as a level 3 officer They get all the base knowledge that they get here. They get the real experience working on the road and the additional training from the agency that they work for. Should somebody that comes out of a level 3 basic academy class be able to go right into working at an SIU? No, they don't have that experience. They don't have, they haven't even done the basics yet of what you would need to do to even think about investigating a sexual assault investigation. So just because you're level 3 doesn't mean that you're suited for that either. That doesn't give you the basis to be able to go and do that. However, having said that, we do have levels of certification. Those levels of certification are because of the training that is provided to those levels of certification. And I think it's with the clear mind that knowing that folks aren't getting the full boat of what they should, and they're only getting a truncated version, we want to limit what they can do because it makes sense. Unless they're under the guidance of somebody that they're working with, they shouldn't be doing cases like this because they can make bad case law. They can make bad decisions. They can do any number of areas of harm. So anyway, I'll stop there because I see we got another hand up and let the council have further discussion.
I just want to comment, Tom, I'll be right to you in a minute, but I think Butch raised an important point, which was, one of my thoughts was, I think we need to review that statute because I see it two ways. One way, given the work we've done with the Alternative Pathways Committee, I think we do need to provide some kind of mechanism, at least some kind of authority that would allow for this kind of assessment of, it's basically assessment of prior learning. Those who were on the committee know we talked about that quite a bit. Having said that, there needs to be some level of constraint on that because these are all good observations about what that authority should be. So I think at a minimum, I mean, Butch raises an important point. Should the statute be repealed and then handle this through other, rulemaking, some other avenue to adapt to the times, or can the statute be modified to enable new direction, right? Because it seems as though it was created for a very specific circumstance that there may need to be it could benefit from some level of revision to move in a direction that I think, at least on the Alternative Pathways Committee, we saw some direction that we might want to go. So I mean, I think that's a good thing to bring up and for us to refocus on. I want to turn to Tom and then Sheriff Anderson. You're up, Tom. Your microphone's up.
Thanks. I had to lower my hand. So I worked in the Chittenden County SIU before I retired from Burlington. It was the busiest SIU in the state. And I can just tell you from my experience that most police officers in general, level 2 or level 3, do not want anything to do with SIU work. It takes a special person. It takes a good amount of training, and you have to be motivated to do the job. So I would say that if we had a level 2 who had the qualification, was willing to do the training, to do the forensic interview training, and to Karen's point, to have enough training and education mixed that their work would be defensible in court, I would have no problem with a level 2 being cleared to do that type of work. I would be I would like to see a subcommittee for this to take it off of Chris's plate, ultimately, where these types of cases on a one-by-one off basis could go to the subcommittee, be vetted, and then be brought to Chris, and or this body for approval.
Thank you, Tom. Mark.
Thank you. I just wanted to follow up on the discussion of change regarding the statute. Again, talking in the circles of this, if we were to consider statutory change, I might want to suggest we consider the change of 2358 in its entirety, which is a pretty big statement. but I'll qualify that with the follow-up of, we've identified times where we can have base level certifications that make sense to things we're dealing with right now. The legislature did its level best to try to create what was recommended by the profession back in 2017 or thereabouts, which then required some adjustments and follow-ups, which was laid out in the history. One of the things that through alternative pathways of the level 2 curriculum review committee or some other committees, the waiver committee, like all of these different bodies who have done work, we've talked about things like we have a well-qualified agency head who has come from fill in the blank agency with all this experience who now has to go through this process, which we've identified for many years has been cumbersome. And could we have an administrative certification for an agency head? Well, the statute is what lays out the certification, not the council. So I would love to see the council become prescriptive to what certifications are granted, to prescribe what those are, to develop a rule to derive what they are. And it could probably be captured based on what is written in the statute. But again, there are some things that are just generally in conflict with common sense that are codified in the statute. Another one I'll call out, level 2s can investigate motor vehicle accidents as prescribed by council rule. I don't think we have a council rule that talks about how they can or cannot do accidents. So I'm fearful that we strike the council's authority here, since statute is slower to change than council rule. Council rule is also slow to change, but we haven't even addressed that since 2017. So should level 2 officers who've completed the crash investigation course be capable of investigating a motor vehicle crash, which oftentimes agencies are even saying, we're not investigating that? Is that the service that we are putting forward?
All right. Thank you. Thank you. All good comments. I want to add, I had a few others, and I think some of them were reflected in the comments so far. And that is the resources required. I think from if you look at maybe a best practices or an organizational perspective, if you have a lot of exceptions, that begs a rule, right? To address those exceptions. Now, as Chris reported, we haven't had the door knocked down. There had been one previous case under the earlier statute. Butch raised a good question. I don't know that I got the answer fully from that. Is what was the specific action of the council? I mean, you mentioned, Chris, that they had sunsetted that provision. But I think, as Butch pointed out, then that really was basically saying we're not going to abide by the statute. I think if I understood that correctly, Butch, it's still in statute, and the council voted not to recognize that. But I understand the reasons why it did that relative to the pool at that time, right? So I'm looking at this from the lens of the conversations we had on the alternative pathways, and the need, I think, for a more systematic approach. In the case of that committee, we looked at getting from level 2 to level 3. I know we're talking about very specific certifications here, but they impinge on that whole concept of, what's that scope of authority? What is a level 2 then? Right? So Chris, I see you have your hand up. I'm sure you're responding to my question.
No, well, just relative to the level 2E process and the sunsetting question. And as Chris Burkett put in the chat, the statute doesn't require, but permits the council to expand the scope of practice, which is what the council did. And then they decided to sunset it because it didn't meet, there was not the need for it to continue on. That was the council's action for that. And I think the concerns that I have, aside from what I and everybody else has already addressed here, is that here's one concern, is that we're not hearing voices, and I don't want to speak for anybody else, but I know that the TAC committee has weighed in on, their thought process on level 2 and what should be expanded, or should it be expanded, or what does that process look like? I think another concern I have is that I don't want it to be individualized. This should be, if it's a process, it's a process. And we have a a process that everybody that wants to follow it can attempt to follow it. I struggle with that, even saying that, because when I look at the individual that applied just on paper, I think to myself, this is an ideal candidate. This is exactly what you would want in somebody to do this work. Somebody who wants it, somebody who's qualified, somebody who's had additional training in the areas that you would hope that they would have to do that type of work. And the only thing holding them back is the fact that they don't have the level of certification to do it. So I don't want to create a process for an individual because this is the ideal candidate, but I want to create, if there is a process, it's a process that's fair to everybody and that everybody can apply to. All of that said, with no resources or additional staff to make that happen. So this is why I wanted the conversation to start taking place. I didn't expect to get an answer today, but I also know that there are other people that might want to weigh in or that didn't have the opportunity today to do so. So again, I'm happy to listen to any more conversation. I just wanted to make sure that I think after hearing these conversations today, there might be others that want to weigh in on this topic.
Karen.
Just a brief comment. I think that this idea of having others weigh in is really important. I think that it would be, regardless of what process we develop and who sits at that locus of decision making, I think that we have to make a provision so that there can be some, if needed, folks with outside expertise, topical expertise could weigh in. I would have a lot of opinions about somebody doing investigations of domestic or sexual violence based on my experience. And I would be hard pressed to offer any kind of expert opinion on most of the questions that are or most of the certification alleviation that might be brought up on law enforcement topics. I don't know the first thing about investigating a felony as a DUI. So I think that it's really important that the process includes the ability to consult with expertise. Thank you.
Yes. I would agree. I guess the thing that still that's in the back of my mind is that, and it was pointed out in several of the comments, this can be a labor-intensive process. And as you mentioned, Chris, with staffing demands to be able to do this. But I think it does beg for some type, and I heard this again in a number of the comments, some type of procedure, right? Some types of standardized approach. And I heard earlier in the comments criteria, right? Very some specific criteria. I think those are the types of things. And I know we talked a bit about this in the Alternative Pathways group, but this is a real live case for that. So, and I guess maybe another thought too is I heard looking at removing, I don't know if it's the best, I'm using the right words here, but removing the decision from the executive director. And I think I heard, having whatever the committee is that do this based on those procedures and committee and criteria. But that wouldn't, I don't necessarily think that if you did that, that would take the executive director out of the loop. The executive director would still have final decision. In other words, the committee would be making the recommendation to the executive director, or there could be an appeal to the executive director based on that process. But we're talking about a process and procedures that we don't have, right? And I think this begs the question of needing to have a serious discussion about what those are. And that's been my concern. I saw early on in the discussion with the Pathways Committee, the strain and the demand this could put on a waiver committee, which could be pretty significant. If it's one, that's one thing, but if it's 10 or 15, now that's a very resource heavy, to do it properly. That's a very resource heavy demand on the staff, and particularly in the absence of rules and procedures. We have Butch and then Justin. Butch first.
Well, here I am, the skunk at the party again, Mr. Chair. So we have current law in the books. An applicant, and sounds like a qualified applicant has applied based on the current statute. But yet, because the decision was made by the council not to abide by the current statute, the law's still there. So where does this leave the current applicant? Does it leave them some sort of a limbo? If we go forward and set up a new policy, change the statute or whatever, where does this person stand today? I have no legal background on this, but I'm assuming that if I was the applicant, I would be upset that we possibly could be creating a policy that would preclude him or her from just taking advantage of the current statute. So it's just a question that's kind of rolling around, and I don't want us to get ourselves in trouble by changing our policy keep this person from gaining access to a position that he's looking for.
Yeah, I think, Butch, I would just like to clarify, I don't look at this as the council ignoring or not following statute. I think that the council's prior vote to sunset was a process they created to create a level 2E, which wasn't written out in statute. It was just following the statutory language. They created a process and called it level 2E for an exception to that. And then they sunsetted it when they felt it was appropriate because there were no other applicants. The problem that I face is that the statutory language provides an opportunity for somebody to apply, but we don't have a process set up for it to take place. And it's not one I'm willing to jump to or quickly make decisions on because of the nature of this specific topic. It could be, somebody that wants to do, accident reconstruction. They're certified in that. And that wouldn't give me as much heartburn as this one does because of and not that the ramifications could be any less, but having done a lot of those investigations myself in the past, you don't want to make mistakes here. So when I think about this, I'm not looking at it as the council isn't doing their job. We just need to figure out, is that a process? How does that become a process that's fair to everyone that feels that they have what it takes and the prerequisites to get through that process, and then granting that certification and staying within the statute that is existing? Or does this council feel like we might need some modification to the language in the statute? Or maybe we don't, we keep that, and maybe we work through the rules committee to decide, let's refine what the rule looks like so that it's clear to everybody what they have to do. That's all. My only disagreement with your couching is I don't feel like the council is ignoring the statute. It was a process that the council set up and then sunsetted.
Thanks.
My understanding was the Chris Burkett, you noted in the comments that the statute permits, it doesn't require. Is that correct? It permits the council or the academy it permits, but it doesn't require. So that really sheds a little bit different light on whether the statute's being ignored or not. But I'm splitting hairs. I mean, I hear what you're saying, and Chris, your dilemma now about needing more definitive guardrails, if you will, on how to make that decision as the ED, because it does sit on your desk. Justin.
Thank you, Mr. Chair. Hopefully you can hear me. I apologize. I'm traveling and I don't have a phone holder. So rather than looking at the roof of my vehicle here, I'm just going to leave my camera off. But I agree with a lot of what's been said, and I disagree with a few things, and I'm just going to highlight the things that I disagree with. And it's not strenuous objections, but I do think there should be a prescriptive process by which someone could attempt to request one of these waivers. But I don't think I would say that actual decision or what that decision is based on, I don't think should be as prescriptive. And that's because I feel like on the waiver committee, we get a number of different applicants with a number of different situations and a variety of different trainings and all this other sort of stuff. So I think a prescriptive process would be great, but I think a committee making a recommendation to the executive director based on what's provided, I think would be one option. And to that point, the only other thing I wanted to say was that, and this is maybe a little bit naivete of me, but to the director's point about the workload, if I was the director, I'd say I feel like it's a societal thing. What's the academy going to do to accommodate this? We're not going to do anything. You do the work. You bring the documentation. You do the background. You do everything that is required to get the approval of the committee and the director to say, yes, this candidate meets the criteria necessary to be granted a waiver to perform X task or X function. And maybe like I said, maybe that's naive on my part, but that's how I think this ought to be approached. And on the waiver subcommittee, we definitely see where agency heads and individuals wanting a waiver where they take time and effort to make their case, and we see the ones that don't. And it doesn't mean that we don't necessarily grant the ones that don't. It may not be a significant issue, but we have absolutely rejected requests because there's simply not enough information. And until the agency head or the officer asking for the waiver does the work, like that's on them. And I think this process ought to be run similarly in that anybody asking for this exception, the onus is on them to prove that they deserve it, not on the academy or any academy staff to gather enough documentation to validate it. So that's my 2 cents.
Yeah, that's a good observation, Colonel, because I think the parallel, in education is if you're looking at this as a portfolio, you're presenting a portfolio of your requirements. The issue and the onus is on the candidate to prepare that portfolio with the greatest degree of detail that's possible that relates to the standards, right? So I can see there might be a middle ground here, but having said that, this goes back to, again, providing more clarity on providing the criteria very clearly and the process for collating that material and what's expected, right? So that the committee can do its job well. And I think that's another area that we need to look at getting some more clarification on. Sheriff Anderson.
Just following up on the 2E. So going back to the history of it, this tiered certification program came out of Act 141 of, I think it's 2014. And there was a glaring omission made, which by the legislature, which was that I believe level 2 couldn't enforce any motor vehicle law. It wasn't intentional, but part of the authority granted by the legislature in Act 141 was that the council could create additional scopes of practice, which a lot of it came around this concept of DUI enforcement. So we had officers who had completed the council's approved standardized field sobriety testing program, how to use at the time, the DMT or the evidentiary breath test and these things. The council, as I recall, I wasn't there, but was watching from the outside. The council permitted the ability to do these things, and the legislature in the next session came back to say, there's a whole list of crimes that we want level 2s capable of investigating, or things that they are capable of doing that they have training for to do. So where I guess I come back to this, we have an existing structure. It might not be for the use case that has come to the director around the SIU investigations, but we do have an existing structure that works around certifications. We have an FTO certification. We have a use of force instructor certification. We have driving instructor certification. So there's ways that I think we can codify it. A lot of it's built around instructors, but if we said, this is how you do sexual and domestic violence investigations, what's that look like? We can look to some of the national data, which is what most of our SIU investigators do. While I'm trained as a level 3 officer, I have qualifications. I worked in an SIU. I wasn't trained on any of the practices that are considered best practice. I'm not the person you want to come investigate felony level domestic violence without supports. And I know the supports to access. So even I, with the level 3 certification, should not be doing those things. I should not be doing a death investigation, especially if it's a homicide, because I don't have a death investigation certification. These are things we have, and if we had these things where we said, this is what a DUI investigation does. This is what death investigation does. Sex assault investigation, SIU investigations. We pull people like Tom Jeanette, who's worked there for many years, to say, this is what a qualification is. And we find value in either bachelor's or master's level degree, which most of law enforcement doesn't get. So I think we could build out a structure like that without us looking at the one-off, this person is a well-qualified candidate, where do they stand right now? Well, we don't necessarily know. We can have a process that says, to the colonel's point, you haven't done the things which are to complete the class. So while you're well-qualified, complete the class, and can we deliver the class? So I think there's a structure that we can build that says we want the person trained and able to deliver, but also doesn't necessarily come down to the base level certifications, which then solve a lot of the complaints I would make with why can't a level 2 do a level or felony DUI when it's reading one line on a criminal record. That's a low-hanging fruit issue, but it's not a low-hanging fruit issue when we talk about sexual and domestic violence. So I think it is an opportunity, but to the director's point, to everyone's point, there's a lot of work here if we deal with this one-off, and it's hard.
Sorry, I'm off mic. Ken?
Just
Then
real
think
quick,
we'll
and I
wrap-
appreciate
we'll wrap up.
all of the comments so far. And I agree with Mark in a lot of respects, particularly where DUI 3 is concerned. The one concern that I do have, though, when we're talking about the differences between a level 2 and a level 3, is not just that specific scope. In this case, traffic or DUI, it's all the things that come after. Are they capable of writing an affidavit, a charging affidavit? Have they had experience doing that as level 2? Do they know what the officer safety procedures are in making a felony arrest? Do they know when to Mirandize someone? Do they know all of the follow-on things to do as a level 2 that a level 3 may or may not know at that point? It's all based on experience at that point. The foundational for much of that is encapsulated in the differences between the level 2 training and the level 3 training. And that's going to have to be something that not just the very specific sexual assault investigation, interview and interrogation, forensic interviewing, it goes beyond that. And it's going to be up to either the council and or the academy to decide, yes, that's great. We appreciate all of the additional training you've received. Now give us some sort of litmus to understand what your further experience is and the rest of scope of practice that you haven't had the ability to practice yet. Thank you.
Thanks, Ken. Trevor?
Yeah, and thanks. I'm just to bring even a little more together in my years of working in an SIU is that I understand the desire to have specific certifications for, let's say, a level 2 that wants to work in an SIU. But what I worry about is that if they don't have the robust level 3 training, they may be too isolated. For example, you're conducting a child sex abuse investigation. What if it morphs into human trafficking? What if it morphs into unlawful restraint? How do we determine what elements of training they have to do this one additional scope of practice? But it could morph into something else as they're headed down this path. So, I think it's fine that we have an opportunity for people to apply for an additional scope, but I think it's going to take an incredible amount of work to really envision what are the metrics we're going to look at. And I know, Chair, you mentioned, getting credit for prior learning, presenting a portfolio, but really what are we looking at in law enforcement? Investigations can quickly morph and take turns that we hadn't intended. And if we've given you a specific certification, now all of a sudden you take a hard left in your investigation and now you're out of scope again. So I just think that if we do move forward on this, we need to be thoughtful. It's going to be a lot of work for somebody. I'm not opposed to it, but really would want to venture into it eyes wide open.
Thanks, Trevor. I think we've had a pretty robust conversation here today, and I hope it's, I don't know that it's provided the direct answer, I think, but what I'm hearing is a call for more clarification, both in process and criteria, and assessing the competency, et cetera. Chris, I don't know if we've helped you that much in this conversation today, because you do have the case at hand, right? And that's usually what prompt these kinds of discussions. It's no longer a esoteric or theoretical case. It's an empirical case that will have to be some type of decision rendered on. So, Chris, do you have any closing thoughts? I mean, I think this is all we want to, capture the issues that were raised in this conversation and continue that discussion. But Chris, do you have any closing thoughts or questions?
I think for me, closing thoughts would be, I would like to continue this conversation into another meeting and maybe clarify what, where we see things that make sense, where, as opposed to where we see things that could be roadblocks or barriers, and then what are the pathways to try to fix those? Because this is very, very similar in my mind to the process that we went through with the one level 2E officer who had been asking for 2.5 years. So he says it's in statute, how do I get that? Well, there wasn't a process. And so we went through several iterations back and forth between chiefs and sheriffs discussing this. And, what if we have people that want to do this? And everybody, including the applicant, was very patient with that process, understanding they want to get it, and they were willing to wait for us to work through what that process is. I think from my perspective, regardless of whose decision it ends up being, I do see this as something that's looked through the eyes of a committee that has the work done by the applicant themselves to present their case, and then a recommendation that comes to me where I make a recommendation to the council that they vote on, because regardless of the decision I make, anybody can appeal my decision to the full council. So I would like it to be a recommendation that comes from me to the council based on some concrete facts and some material that the council can digest and either agree or not agree with, because it would come ultimately to the council anyway.
Okay. Lots of issues here. We certainly didn't resolve them, but I think we carved out at least some direction on the issues that need to be addressed and where there needs to be some clarification. So this is ongoing work for sure, and I think it's going to end up back on our agenda in committees. So we'll certainly work with the executive director on this and developing a pathway to kind of sort through these issues. But it was a good discussion, and I think it's relevant in the context of the work that the Pathways Committee did, because this is part of that. This is at the heart of that at some level. I don't want to say it's exclusively. I think there's a lot of many good issues raised about, I think, would be collateral issues, right? That would come with level 3 or other more advanced certification that isn't just in a specific area. So I think, we definitely need to be mindful of that. Okay. Good discussion. To be continued in a variety of forums and at this council again. I will move on to the last item on the agenda. Well, next to the last item on the agenda, which is general discussion. Are there any items for the good of the order or announcements that folks would like to make about things that are going on or changes, their agency, etc.? I know we're probably pretty worn out. We're afternoon, so. Okay, hearing none. I neglected earlier on. I also wanted to thank the staff at the academy. The graduation went off smoothly. New layout in the gym for the graduation that I thought was nice. I thought it worked very well. Much more intimate with the audience, close to the graduates. and all the work that went into that. So thanks for that. And then as we close the year, certainly like to thank the council for all your good work, both things that we've done in general council, but also in the many committees. I know that there's a lot of work that goes on, a lot of work. I've just been drafted into a new committee. I won't mention which one that is, but I suspect my workload just increased. So Sheriff Anderson's smiling. He knows what I'm talking about. But looking forward to 2026. Final reminder, we have a hearing on the 16th. So we're going to need, all hands on deck to be able to participate in that for a full and fair process. No further announcements. I will entertain a motion to adjourn. Waiting.
So moved.
Sheriff Anderson. Okay, I knew that we would have that. Second.
I'll second Peterson.
Okay, we got the second for Major Peterson. Okay. I think this will be by acclaim, so let the record show that we have adjourned at 12:04 p.m. Yeah, I look forward to seeing folks on the 16th. Have a good remainder of your week. Thank you.
Thank you.
Take care.